think we'll get started, everyone. Welcome. My name is John Boscariol. I'm a lawyer at McCarthy Tétrault, which is a law firm that, in addition to having offices here in Montreal, we're across Canada and in the United Kingdom and New York City as well. I'm the only thing standing between you and Donnie Brasco this afternoon. So I feel the weight of this on my shoulders. I still think this is going to be interesting for you to listen to, though. We're a nice, small group, tight group here, so I'm going to encourage you to interrupt me, ask any questions as we go along. I'll try and leave a bit of time at the end for questions. Make sure I've got my time here. What I'd like to cover today, well, let me back up a bit. At our firm, give you an idea of what we do in this area. We do a lot of internal investigation, defense work, enforcement work, compliance work, all in the area of what I broadly call trade controls, which is, it includes economic sanctions, export controls, military controls, but also anti-corruption. And that's a big part of what we do, and a large part of that practice is working with our corporate lawyers who are acting for underwriters, acquirers, private equity, banks, in transactions where anti-corruption has become an issue. Now, this is a recent phenomenon. 10 years ago, anti-corruption and trade controls in the commercial context, so as a topic for due diligence, wasn't a big topic. But as awareness has grown in this area, as we've seen very aggressive enforcement, particularly south of the border, as we've seen huge penalties, this has become a big deal. And the way we've explained this to many of our clients, we tend to act for the investors or the acquirers of companies, so, but sometimes we'll act for targets as well. And the way we explain this to targets, whether we're talking about a junior in the mining industry or a startup in the tech sector, is that these issues go to the very core of your business, the value of your business. And put aside all the enforcement activity we see out there and the penalties, I can tell you that on the private side of things, this is being enforced in the business community by acquirers, by people that want to do business with you, potential joint venture partners. It used to be that it was always the Americans, and it tended to be the Americans who pushed these issues on due diligence, but we're seeing it now with Canadian investors, European investors, investors from all around the world are doing deep dives in their commercial transactions and their investments to ensure that the targets or whoever they're dealing with have effective compliance in the anti-corruption area. So a large part of our practice, in addition to the regular compliance and enforcement and defense work, is due diligence. And as I said before, working with our lawyers on large transactions, particularly where the target is operating in a sensitive industry or in a sensitive country abroad. So today I want to focus on a couple of things. I think by now you've already probably have a sense of what the enforcement environment in Canada here is, given the other panels you've been listening to. But I want to talk a bit about how that's impacting these commercial relationships and the negotiation of these relationships. So whether we're talking about mergers and acquisitions, IPOs, so initial public offerings, private equity investment, debt financing, commercial bank lending, or joint ventures. Again, as I said before, the parties are insisting on having solid, deep due diligence as part of that process. So what we say, even to the small business owner or the executive who's looking at going public, the tech executive might be looking at going public at some point, you have to have all your ducks in a row to begin with in this area. And I can't tell you, excuse me, how many transactions we've seen where the target just didn't get that message. Canadian companies are particularly vulnerable in this area, and I'll talk a bit about the mining and oil and gas sector, but Canadian companies tend to go where their competitors may be a bit more fearful. So we've had lots of examples in the transactional context in Canada where we're looking at a target who has gone into the Middle East to provide oil field service equipment in the Middle East, where the competition was not that fierce because American companies generally were prevented from going there because of sanctions or the feeling it was high risk from an FCPA point of view. In those transactions, and this is still happening today, we're seeing Canadian companies that just didn't get the message. They don't have a compliance program in place. Or if they have a compliance program, it's a paper program. Everyone's familiar with that expression, paper program? So you'll hear this from the RCMP and others that companies will, and companies come to us and ask for this. They say, we'll pay you $5,000, $10,000, $20,000. Please give us this document. We need it for our board to basically rubber stamp, show that we're doing something in this area. And it's something we don't do, and I know a number of other law firms won't do that because they are worthless. In fact, they're probably more harmful than anything else. You really have to have an effect, and I'm sure you've already heard this today, and you'll hear it tomorrow as well when we do a session in the morning. You have to have an effective, risk-based, implemented compliance program in place with evidence of implementation. This is what we look for on the due diligence side when we're examining targets for our clients. So that's a message we're often giving to the small and medium-sized businesses out there that are in those high-risk areas, that are operating, oil and gas operations in the Middle East or our mining operations in West Africa. We're not saying don't go there. We're not saying that at all. We're saying that you've got to properly address the compliance issue, have these measures in place, be prepared to make those hard decisions on the ground when they come up, because in the future, whether you're going to go public, whether you're going to look for bank financing, whether you want to be acquired by a bigger operator, a major in the mining industry, for example, they're going to want to see all this. They're going to want to see evidence that you actually have a compliance program in place. And we're still seeing transactions that have been delayed significantly or actually fallen apart because the target didn't have a compliance program in place. So that's a bit about what we'll talk about here today, although largely from the perspective of the investor. So whether you're in private equity or if you're in a bank or you're in a large company that's looking at targets on a regular basis, these are the kinds of things you would be asking about. And even if you're not, if you're on the other side of that, hopefully we're going to give you a good sense of what to expect when you're going into M&A discussions or looking at a joint venture with a larger party. So just a bit of background on this. When we usually advise folks on these issues, we we don't try to scare them, but we kind of try and give them the sense of why it's important to have a compliance program in place. And of course, we talk about hard costs of compliance. So the penalties in Canada, it's primarily criminal penalties. You can have fines, you can be subject to imprisonment. We also talk about operational costs, and this is something that comes as a surprise to a lot of companies, particularly targets. When we're doing due diligence on a target and we find an issue and the target can't properly explain it to us, often we're doing a kind of mini internal investigation within that due diligence process. And for those of you that are involved in due diligence, you'll know that there's not a lot of time to do due diligence. Often there's diligence at the exploratory phase, an agreement's then signed up, not closing, but an agreement to close is signed up, then you're doing deeper due diligence, and then you're closing. Those are all done in a compressed time frame. Everyone is under pressure to close the deal. So doing an internal investigation within those parameters can be challenging, but that's often, you know, the analogy I draw with it, that when we find an issue, we need to do that within that compressed period, and that can be an expensive process as well. And I've been across the table from many targets who have said, why are you wasting your time with this? Why are you bothering with this? This isn't an issue. And then we dig something up and all of a sudden it balloons into a big issue. They're having to pay costs for the internal investigation, which can be very high, and it's delaying the transaction most importantly, and everyone is getting more stressed out and intense over the whole thing. The other kind of costs we talk about are reputational. So regardless of what the penalties are out there, the fact is today that anti-corruption violations or potential violations have a huge reputational cost. As I mentioned earlier, cost in terms of your attractiveness as a target or as someone to do business with. And that includes goodwill. You see impact on share price. We've seen that with SNC-Lavalin after I guess it would have been back in 2011 when the search warrants were announced and that all started coming out. You saw that impact on share price. We've seen that multiple times in the United States. And debarment is another impact. These investigations and prosecutions can result in a debarment, preventing the company from doing business with government. For many companies, not a big deal. For other companies who rely on sales and services as a big part of their business, sales and services to government, it can be the death knell. So generally, I think as many of you may have already heard, Canada has not had an aggressive stance on corruption in the past. We've had the CFPOA, the Corruption of Foreign Public Officials Act, since 1999. Our first conviction was in 2005. The HydroClean case ended up at $25,000 penalty, was actually less than the amount of the bribe at stake, involved bribing a customs official in the United States. And Canada faced a lot of pressure as a result of that from the OECD, from the United States, other groups, and started to step up enforcement, created offices of dedicated RCMP officers who were investigating CFPOA violations, and that ultimately resulted in the cases that we have now today. So in 2011, we had a conviction, it's actually a plea, by NICO Resources, resulting in a $9.5 million fine and a 3-year probationary period, which was very expensive. Griffiths Energy followed that in 2013, again, a plea by a company, and they paid a $10.35 million fine. We've had an individual be convicted under the act and sentenced to 3 years in jail, and most recently Carrigar's appeal to the Ontario Court of Appeal in August was dismissed. So Canada has started to get a bit of a record of convictions in this area. We have a number of ongoing investigations, but the last major conviction on the corporate side was about 5 years ago now. So we're told that there's others in the pipe, there are investigations ongoing. Charges have been laid with respect to SNC-Lavalin and its activities in Libya. We have a new, relatively new, it was announced last year, another case against the president of Canadian General Aircraft with respect to aircraft sales to Thai public officials. But overall, I think it's been relatively quiet. So I think people are watching to see what's going to come of SNC and some other developments to see how this might actually play out on the Canadian side. Certainly, we've learned some lessons from the enforcement to date in Canada. I think if you do look at what the judges said in both the NICO case and the Griffiths Energy case, Canada does not accept that bribery is an acceptable way of doing business. This is not business as usual. This is not something that we're proud of here in Canada when our companies engage in this activity. Certainly, it's no excuse for you to say that we see the Russians bribing, we see the Chinese bribing, therefore we should be able to do this if we want to compete in the world market. That's just no longer acceptable, although you know, at one time, many years ago, it might have been. We've also seen the benefits of voluntary disclosure, and if you take a look at those two cases, the NICO case and the Griffiths Energy case, you'll see in those circumstances that there were two very different results. The amount of the financial penalty is roughly the same, but interestingly, in NICO, the company did not come forward voluntarily. They, in fact, were investigated for 3 years or so. They certainly, when they found out they were being investigated, they cooperated at that time, but they didn't come forward voluntarily. Griffiths Energy did. And the result is that in Griffiths Energy, you know, we're looking at a roughly $2 million bribe, plus the founder's shares in that case. They ended up with roughly a $10 million penalty. In NICO Resources, it was about a $180,000 bribe in total that resulted, again, in, you know, roughly $9.5 million. So the RCMP often points to that. And my co-panelist, Pat Poitevin, tomorrow in our morning session will point to that as evidence that if you do come forward voluntarily, you'll get a bit of a break. But that's the only real example we have in Canada. The other difference between those two cases was NICO was subject to a 3-year probationary period, very expensive for NICO, whereas Griffiths, who came forward voluntarily, was not subject to that probationary period. Certainly, we saw the effects of those cases. For example, on NICO, there was a 4% loss of market share in based on their stock decline when that plea was announced. We know SNC-Lavalin had been going through some difficulties as a result as well. Griffiths, too, was in the midst of an IPO when that was discovered. That IPO had to be terminated because of that, and obviously they lost all the costs associated with that IPO. In terms of the operational costs, the Griffiths investigation, it was made public, cost $5 million alone for the internal investigation costs. That doesn't count the costs of remediation or compliance programs. Nordian is another example that's not a conviction, but that was an investigation. The compliance costs for Nordian were in excess of $20 million, and that was reported publicly as well when they were investigating, as well as having to put in remedial measures for potential anti-corruption violations. Let me move a bit ahead here. So on the M&A side specifically, these issues are being identified in M&A transactions now. And I'm educating our corporate lawyers about this type of thing, what we need to look out for when we're acting for acquirers, but also when we're acting for targets. How we prepare targets for this process, again, emphasizing the importance of having a real compliance program in place with documented evidence of implementation. That means that if you say that your third parties are going to undergo either monitoring or screening, in fact it should be both, screening at the beginning and monitoring on an ongoing basis, you have documented evidence of that. Those of you that were in the session, the last one just before me, where the speaker talked about all the things you should be doing with third parties, that all should be documented, so that when someone comes along, not just the RCMP, if something goes wrong, God forbid, you're investigated, but when an acquirer comes along or a potential business partner comes along and is doing this due diligence, you're in a position to demonstrate to them that This is not a paper policy. This is something that's actually implemented on a regular basis, and we can show you the documentary evidence to that effect. So there's a few interesting kind of cautionary tales on the M&A side from the US. And generally, as is probably not much of a surprise to you to hear that a lot of the principles we develop on the compliance side kind of flow from the United States, because for better or for worse, they have been a leader in this area in terms of enforcement. So we take a lot of principles from the FCPA in the US and tend to apply them here in Canada under the CFPOA. We also take a lot of lessons from the very rich record of enforcement that you see in the United States, and a very public record of enforcement and negotiated deferred prosecution agreements and so forth that we don't have in Canada. So, you know, on those examples for the guilty pleas for Griffiths Energy and NICO, those essentially are the only ones, and you have to go to the court records and get the transcript from the court to get that information. The United States has this huge record and practice of deferred prosecution agreements, which we don't have here in Canada yet, and other voluntary disclosure mechanisms where these things are public, so we can get a lot of this, and it's an important resource. So I just have 3 examples here of cases in the United States on the M&A side where things went bad. The second one, things were okay. The third one, things went very bad. The Titan case was an acquisition, $2.2 billion acquisition by Lockheed Martin of Titan in the United States. And during that pre-closing phase, Lockheed Martin had identified that Titan had engaged in suspicious payments with respect to public officials in Benin. And Lockheed Martin, I guess there was almost a mini investigation. They had delayed the closing a number of times, and finally it was decided, Titan, you should report this to the US authorities. And Titan did that, and the US authorities started investigating, and it just got to the point where Lockheed was no longer interested. They walked away from the transaction. Ultimately, the US authorities imposed a $28 million fine on Titan. But even worse, the $2.2 billion deal was scuttled. And that resulted in a loss of that deal, and obviously Lockheed Martin went on without Titan. The second example, Envision situation where GE was acquiring a company, Envision, that sold baggage screening equipment to airports. During the diligence, GE discovered that there were issues around potential payments to Filipino, Chinese, and Thai public officials. In that case, they actually disclosed to the US authorities and were able to negotiate payment, a resolution with the SEC before closing, and then a resolution with the DOJ after closing. And it was I think it was actually the first instance of a non-prosecution agreement with both the DOJ and the SEC in the United States. So it enabled them to get comfort that the company wouldn't be prosecuted. At the same time, they paid a penalty. I think the first one was roughly $800,000, and they put in remedial measures going forward. So at the end of the day, that was worked out. Obviously, there would have been delays and extra costs in the acquisition, but it was worked out and they were able to move forward. The third example was much more disastrous, I think, for all involved. This involved an acquisition by a company called Elandia of Latin Node, a telecommunications company. It's unclear as to what, based on the public record, what actual anti-corruption due diligence was done before the acquisition, but Elandia acquired them in February of 2007. By August, they had realized that Latin Node had some suspect payments to government officials in Yemen and Honduras. They disclosed it to the Department of Justice and the SEC, and from there everything just went downhill. They ended up firing the CEO of Latin Node because they were now imposing more strict conditions and controls over how they dealt with vendors and public officials. They actually lost a lot of customers and vendors, which should tell you something. And they had to discontinue the operations. They did this by the end of 2007. So in the matter of less than a year, this company was shut down, even though Elandia had paid $23 million for it. On top of it, they had to cover all the costs of the investigations. There was a penalty imposed as well. All kinds. They had to terminate the president, and there were costs involved in that as well. It really appears they just didn't do the sufficient due diligence up front, but it's just an example I present to you of really how things can be disastrous if you're not paying attention to these issues at the beginning of the transaction. I mentioned about always going to the United States, not always, but often going to the United States for resources in this area, and the DOJ and SEC in the United States several years ago now, back in 2012, put together a resource guide for the FCPA. And in that resource guide, they talk about these very principles, that if you're entering into these transactions, there's both legal and business risk, and it is expected that you would conduct effective due diligence on your acquisition targets because you don't want to essentially inherit an FCPA violation. They have examples, I'll talk about one in a few minutes, where they have declined to take enforcement action when something has been discovered in the due diligence process. And the acquirer says, we're going to fix this. And that's essentially often the plan you can go with this. Now, in the Latin Node case, obviously that it didn't unfold that way. But the idea is in that due diligence period, which I described before as being really a high pressure period, everyone wants to get the deal done. There are scenarios where if you do discover something, provided you're kind of moving appropriately and quickly, you can fix this before closing. And certainly there are examples where the US government has said, listen, you know, if you have to rush this, and I'll give you an example of that, if you have to rush this, what is expected at least is that on day one when you come in, you're going to do due diligence right away. If you discover something, that's going to be disclosed, and we're going to deal with it in a very short period of time. The speaker before, who talked about third parties, talked about this principle of risk assessment, and this is fundamental across the board for due diligence, whether you're dealing with your compliance program, how you draft your compliance program, whether you're dealing with the assessment of third parties, whether you're dealing with project by project risk assessment, or in this case, the assessment of risk in M&A transactions. And so we usually tell clients, and this is where we would assist them with at the beginning, is let's look at the risk factors present in the transaction you're about to undertake. All of these should be familiar because it's the same thing you look at in terms of risk assessment of third parties. Nature of the foreign jurisdiction in which they operate, what's the industry sector, obviously you know, going into a mining company that's operating in Africa is a very different risk profile than dealing with a software company that only sells its products in Canada and the United States. Look at the target's reliance on government licensing and concessions or permits. What proportion of their revenues or sales are to government entities or government-owned entities? Look at their contracts with government, and this is a whole other area of exposure as well. If they have concessions with government or sales to government, often those contracts contain debarment clauses. So if there is corruption, the government can terminate the contract. And for companies who have, say, a mine in a country and that's their main asset, and if the government has the ability to terminate the concession agreement associated with that mine, if there's corruption, obviously that's a huge exposure for the company. And your anti-corruption due diligence is going to be critical in determining whether this is a company you're going to want to acquire. The other things we look at, their claim discounts and rebates. That's often a red flag for corruption. The degree and frequency of their interaction with state-owned entities, their reliance on third parties. There's some businesses that don't have to deal with third parties at all. There are other businesses that, when they go out of Canada, only deal with third parties in terms of their activities with other countries. The degree of government regulation. So, you compare software sales versus telecommunication. Obviously, the latter has a lot more government regulation. The target's compliance culture, its level of sophistication in this area. You'll want to see the target's policies and procedures, its training, how it's dealt with employees who have violated those policies and procedures. Again, you want to get evidence that whatever they're showing you as a written compliance policy is actually implemented on the ground. You'll take a look also at any past violations that they've had. And so in this presentation, I think you can get from them, from the conference organizers, a copy of this as well. So I won't go through everything, but this is basically our standard first 7 or 8 questions we'll ask, knowing at first, what the risk profile is of the transaction. But we'll ask them for the list of countries. We'll ask about their use of third parties. We'll get copies of their compliance programs. We'll obviously get a detailed corporate and managerial chart. We'll look at all the government-owned and government-controlled entities they're doing business with. We'll get copies of those contracts. We'll get a list and description of all their permits that they have with the government, at least the current ones, and possibly, we'll go back 3 or 4 years to see what's happened in the past as well. Descriptions of any investigations. So if there's been any inquiries that have come in, not just from the RCMP, but investigative authorities around the world about their compliance with corruption, we want to know about that. But we also want to know about the internal investigations that have gone on. So we'll be asking for information on that too. Those first 7 or 8 questions give us a pretty good picture of first whether we need to drill down more, and then where we need to drill down. So we've had examples of cases or transactions where those first 7 or 8 are answered in a way that we're happy. We think this company's in good shape on the anti-corruption side. And then others where we need to nail down. And so I should say we need to drill down. And so that means sampling transactions. We've gotten into that, retaining a forensic firm to come in and assist on examining the financial records of the company. And that particularly arises where we found 1 or 2 things that really smell odd, and we've decided, and the acquirer's decided that this is worth it, by the way. We've decided to bring in a forensic investigator to take a closer look. And most often the target will cooperate with that. We can get into more specific questionnaires, on-site visits of their facilities. We start doing interviews of their employees and executives, do more detailed background checks. We might even retain some third-party specialists to do investigations on the background. As you get to this stage, it becomes more and more expensive. And you start to be more like a mini internal investigation at this point. So a decision is being made, obviously, by the acquirer, your client at that point. Are we still interested in this company? And if we are, we still need to take these steps to nail things down. After all that due diligence is done, and assuming you're still comfortable with things, there's still steps that should be taken in the agreement itself that you're going to sign up with this company. So whether you're an underwriter in the IPO context, you're an acquirer of a small company in your business, you're a bank giving them financing, any of those contexts, you're going to want to make sure you've got the representations and warranties in the agreement on the anti-corruption side, frankly in other areas as well in trade controls. This will be driven by your due diligence. So if the due diligence has given you some comfort and it's been relatively detailed, you could have some fairly standard compliance reps and warranties that will cover these things off. If there's been some concerns identified, you're going to want to get a bit more creative here. You're going to want to make sure that you have the ability to get out of the deal. In the case where you've done some pre-due diligence before the agreement to acquire is lined up, and you're going to do further due diligence during that period leading up to the closing. You're going to want to have the ability to get out of that agreement if you have some suspicions. And so there's diligence out clauses, and I'm not, as I say, I'm not a corporate lawyer, but I know our corporate lawyers come up with all kinds of creative clauses to make sure that you're protecting the acquirer's interest in this process and giving them maximum flexibility to withdraw from the transaction if something is discovered. And then proceeding with the transaction, I had mentioned before that in the United States, the DOJ and SEC has commented on these situations. Actually, it's the DOJ more so, where you might be limited in doing the anti-corruption due diligence. Now, this Halliburton opinion is from way back in 2008, but it kind of set the standard, at least at the time, for situations like that. In that case, Halliburton was restricted from doing thorough due diligence on the UK company it was acquiring because of UK laws that restricted it in a very strict timeline for the acquisition of the company. And the DOJ said in those circumstances, we would accept that you do kind of abbreviated due diligence, and then on day one closing, you're going to do X, Y, and Z. So in the next 180 days, and it's set out this timeline, 180 days after closing, you're going to be comfortable that there's no problems here. If there are any problems, you're going to report them. And that established this principle, which even lives on today, although I think they're a lot more flexible about it. That is, on day one, when you acquire the business, you still have to go in and do even deeper due diligence than you did during the negotiation and phase of the acquisition. You still have to do deeper due diligence to make sure that everything's onside the company, and then you bring that company within the family or the coverage, if you will, of your anti-corruption processes and procedures, which I assume are going to be stellar. We just have a few more minutes left. I want to just mention something because this is happening more often, I think, and that is the structure of the transaction. I've been talking up to now, about acquiring the shares of a company. There are transactions where you acquire the assets of the company as well. And because Canada's anti-corruption laws really are criminal, they're not civil, there is going through an asset transaction instead of acquiring the shares of the company gives you a bit more comfort. Because if the company has committed something in the past, if you're just acquiring their assets, you're insulating yourself somewhat from their commission of the offense in the past. You're acquiring the assets, you can't be considered to have committed that offense in the past, whereas if you're acquiring the company and that company lives on, they can certainly be pursued and prosecuted for anything that went on in the past. There is, though, a big issue with that, and that is coming into the proceeds of a crime as a result of the transaction. So there's still reason to do lots of due diligence in those circumstances, because if those assets that you're acquiring were acquired as a result of corruption, so let's say you're acquiring a government contract from the target, or something else that could have been the proceeds of a bribe, it is a criminal offense for you to come into possession of those proceeds. In effect, like a money laundering offense. And that's something we've struggled a lot with on asset deals, where we've discovered something's gone wrong in the past, and that's also reason to do lots of due diligence and give you pause before closing that asset deal if there's an issue there. So I'm going to stop there because I think I have 1 more minute left. I wanted to, no one interrupted me. I wanted to leave time if there's any questions or comments on that. Any questions? Yes.
This might be related and not exactly specific, but do you have any insights as to why the United States has made rather more progress in this area than Canada? And then depending upon your answer, to what extent in the two countries might there be relationships to the financing of politics and the extent to which Americans and Canadians demonstrate different degrees of progress in this area?
Yeah, that I could take 20 minutes to answer probably. But let me just comment though on the difference between the Canadian and US environments here. Obviously, as I mentioned before, the US has been a leader, and that started from the time of Watergate, and then what followed was the implementation of the FCPA in the United States. My view is Canada was pushed into this. Not when it involves corruption of Canadian officials, but for corruption of foreign public officials, Canada was really pushed into this. We did agree at the OECD to implement the CFPOA in accordance with the OECD Convention. We agreed, with the UN UNCAC as well in 2007, 2008 to make some changes. But on the enforcement side, there really wasn't enforcement in Canada until we had that push from the OECD and from, the United States and others to implement that. And why that is, historically, the US, after I think going through that experience in Watergate, really brought the hammer down. Now a lot of people will say that since then, there's been lots of hypocrisy on the US side with some of these issues. But on the Canadian side, I think we've just been slower to adopt that. And frankly, we're a smaller player, and it's always the common excuse, and I don't think anyone's standing for it anymore, but in the past, the common excuse of Canadian companies had been, if we are going to operate in those foreign jurisdictions and compete with our very effective competitors from not just, I'm kind of maybe unfairly isolating China and Russia here, but those Chinese and Russian competitors, but at the time, European competitors who were paying those bribes. For example, German companies who could actually deduct them from their taxes. We had Canadian companies said that's why we have to pay this, and politicians laid off that. And it wasn't until we had this huge push after 2000 that things actually changed. And I think it's now, I think, a real change in our culture here in Canada that we finally adopted. But the U.S. clearly led that. Yes, question there.
How ISO 37001 can shorter the deal on the transactions that you have been looking into? You think that's favorable if there's a target that has implemented or been certified ISO 37001
right.
in terms of the M&A anti-bribery that you're conducting? That's one question. The second question will be, what is the percentage of the deal breakers that you've had faced based on the anti-bribery risks that you have identified, just to have a ballpark number?
Yep. So let me answer your last question first. In terms of the transactions I've been involved in, there's probably, I don't know, out of maybe dozens, I'd say 3 or 4 have fallen apart because of the anti-corruption issue. So that's a small percentage, but that's unsuccessful, not closed because of issues in this area. And I say anti-corruption, but that also includes anti-money laundering, economic sanctions, export controls and stuff, all in that, because they're all typically looked at together. But I'd say, at least in the deals I'm getting involved in, and it might be skewed because they get me involved in the deal, 3/4 of them have been, I'd say, delayed, or complications have arisen because of these issues. But they still closed in those cases. Eventually, they're able to work through it. In terms of your first question on ISO, that's interesting. It may take some time for that to kind of go out into the market to see what kind of impact that has. I can tell you, though, as counsel to the acquirer or private equity investor who's looking at a company, that might give us initial comfort that they're ISO certified and everything, but we would still drill down into that and maybe even bring an ISO expert along with us to make sure that they actually truly are, but that these things have actually been, these measures have actually been put in place in the company, because I think there's still a risk that may still be a paper policy. Like, we need the evidence. We have to see the evidence of implementation to get comfortable. But that's a good question. I think, in the coming years, I'm going to expect to see more companies kind of putting that forward and saying, listen, we're ISO compliant and here's the evidence. No other questions? Oh, one more. Sure.
What's your take on the DPA in Canada and the timeline, if it's going to happen or not?
Great question. So as many of you know, there's been lots of discussion and pushing, and I admit I've been one of the ones pushing for Canada to adopt a DPA system, a deferred prosecution agreement system here, that would encourage companies to come forward and possibly pay a penalty and undertake remedial measures and monitoring, but not be subject to or not be criminally convicted. We've had that for decades in the United States, and obviously they've got a huge track record, not only of those companies paying fines and remediating, but a track record of principles to follow, precedents to follow. And in fact, Canada, in the NICO case, followed the Panalpina DPA precedent when they were looking at measures that that the company NICO should put in place. NICO was convicted, but that NICO should put in place for monitoring. So my view is it's long overdue here in Canada. So we had consultations initiated in September on that. I forget the deadline for the consultations, but the government is November, thank you, Pat. November 17th is the deadline. The government is taking views on it. I can't see the government rejecting it. Maybe it's going to be slightly different than the US. Maybe it's going to be more like the UK, where there's some more real judicial participation and approval of these DPA arrangements. But I think we're on track to eventually get there, and I think we'll be the better for it. Great, thank you very much. Enjoy Donnie Brasco.